you're there. Excellent. Good morning, everyone, and welcome to today's webinar. I'm Julie Goodway, and I'm one of the solicitors at Thomas Mansfield, and I'm joined today by my colleagues Alex Kiernan and Amandeep Pooney.
Hi, everybody.
Hi.
For those who don't know us, Alex, Aman and I are part of a larger team of qualified solicitors at Thomas Mansfield. Thomas Mansfield is a Legal 500 ranked firm, and we primarily advise employers in the London and South East areas, but also further afield as well. And it's great to see so many good mornings from everyone. Good morning. Now, today we are going to be exploring sexual harassment in the workplace, and most importantly, how businesses, employers can minimise the risks to themselves with this. Now, I would say this is a particularly relevant topic at the moment. Why? Because a new Worker Protection Act is going to be coming into force in October this year. And that's going to be creating a duty on employers to take reasonable steps to prevent sexual harassment in the workplace. And the onus is going to be on you, the employers, to prevent that and to show that you've done this. If there is a tribunal award that says a successful sexual harassment claim and the employer hasn't shown that they've met that burden, then it can result in a substantial 25% uplift on any award. Hence why it's really important for employers to be getting this right. Now, in today's webinar, Alex, me and Aman are probably going to be doing most of the talking, but we really want this to be as interactive as possible. So please do post your comments, questions in the chat box. And as I say, great to see so many people already saying hello. Don't be shy. There's going to be no daft question. If you're thinking it, someone else will be thinking it as well. So why don't we just kick off today with an icebreaker question. It should appear shortly in the chat box, but if it doesn't, just have a look at the polls section. And what that question says is that according to the government's 2020 sexual harassment study, what percentage of people said that they experienced sexual harassment in the previous 12 months? 42%, 29%, 18%, or 10%? Let's have a look to see what the result is. I'll give you a few seconds. Okay, so the vast majority of people today are saying 29%. Then comes 14%, followed by 18%. Not many people thinking 10. Well, actually, yeah, the vast majority here are correct, 29%. So that is obviously still a large, a significant number of people that are saying that they experienced sexual harassment. That doesn't mean to say that they reported it to their employer, but that they experienced it. And actually, that survey probably is worth having a quick look at if you ever get a chance, particularly the summary. And one of the things that particularly I was noticed was that men as well as women were saying about how much they were harassed. Men are just as likely almost to be say that they were sexually harassed as a woman, and that the perpetrator in both instances can be a man or a woman. So let's then kick off with our seminar with a question of what is sexual harassment? Aman, can you tell us how that is defined in law? You're on mute.
Sorry. Yeah, thank you, Julie, and hello to everyone in the seminar today. So I just wanted to start off by showing everyone a slide that should hopefully come up here. So this is the legal definition of sexual harassment that's set out in section 26, subsection 2 of the Equality Act. And what you can see here, that something to meet the statutory threshold of sexual harassment, it needs to be unwanted conduct of a sexual nature, which has the purpose or effect of violating someone's dignity or creating an intimidating, hostile, degrading, or humiliating or offensive environment. And it's this definition and these key terms that we bolden for you, which we're going to spend some time today really going over and looking into.
Yeah, so thanks for that definition. It is really very specific. And obviously, yes, we do need to break those components of that down. So why don't we look at the first part of it first? And that is that the conduct, the sexual harassment conduct, must be unwanted. Aman, what does that mean?
Yeah, so unwanted is a term which isn't really given much in the way of definition within the Equality Act. So as a result, it's always helpful to try and find further guidance. And one of the most helpful sources, and one that we recommend parties look at, is the Equality and Human Rights Commission guidance, the most recent of which is from January 2020. And in this regard, the guidance itself just provides a really useful starting point to illustrate some of the points which can be found within the Equality Act. And I'm going to be referring to the Commission a number of times today, so I'm just for the sake of ease going to call them the EHRC going forward. And the first thing that they say is that unwanted conduct needs to amount to being unwelcome or uninvited, and it doesn't necessarily require there to be any explicit rejection beforehand. And single incidents of harassment can indeed meet that statutory test. So when we think of sexual harassment, we might have this idea in our mind that it needs to be a campaign of harassment against somebody. That's not necessarily the case. It can be one-off incidents as well. So I think on the surface, thinking about what might amount to unwanted and unwelcome conduct seems pretty straightforward. We can see that in practice almost just on the surface. But I think when you actually unpick it and look closer at what has been sort of decided by the tribunal, you can see that actually it's a much more complex matter, especially when you consider issues relating to relationship dynamics at work. You know, there might be existing relationships between colleagues, and this could really complicate the interpretation of what behaviour may be considered welcome and what might be considered unwelcome in those senses. So you really need to consider the context. And there's a case that sort of illustrates this point of the Chief Constable of West Midlands Police. So here you had a case where there was person A and person B, and there'd been a consensual relationship for about 18 months between these individuals. It got to a point where person A said that they wanted to leave their girlfriend and begin a full-time relationship with person B and propose marriage. It was at this point that person B decided that she wanted to end the relationship. However, person A persisted in trying to get the attention of person A. And I think the judgment itself says that he pestered her and pleaded for her to accept his marriage proposal, him escalating his concern, her escalating her concern about him. So the question for the tribunal was this a case where the relationship could be defined as being unwanted conduct? And they said that indeed it was, that there was a point where their relationship had got to such a stage where it would cross over into that place of becoming unwanted conduct. So looking at the dynamics of relationships in context is really key. Another thing that also needs to be taken into consideration is authority and people in positions of authority. And I think this might be most relevant in the circumstances which we as practitioners, I think I can speak for Alex and Julie in this respect, run into the most when it comes to harassment claims, which are workplace banter, jokes in the office, which seem to be maybe possibly have been intended to be innocent, but could obviously go over to that line where it can become unwanted. And there is a case called Smith v. Renrod, which really makes this point very clearly. Here you had Miss Smith, who actually engaged and participated in this banter in the office. But there was a point where it was said that this banter crossed the line, in particular in relation to the conduct of her manager. He would try to kiss her in the office. There were also instances where he would send a text message in a group where he insinuated that he wanted to have sex with Miss Smith on his desk. Now, in this dynamic, that behaviour may have been given the appearance of being welcomed based upon the fact that she indeed participated in similar type of conduct, but there was a line that this crossed, and that line went beyond what would be considered welcome into becoming unwanted. And in this regard, the tribunal also made the particular point of stressing the authority that the manager held. And that power imbalance is something that people really do need to consider when confronting sexual harassment, banter type situations in the workplace. Here, it was a case that Miss Smith was getting this behaviour directed at her from her manager, opposed to just a colleague or contemporary of her. It was coming from someone, a peer. And as a result, there may be difficult in that situation to express that the conduct is unwanted, because there could be a fear of negative consequences, of possible retaliation. So these are all factors that you really do need to bear in mind as well. And if I can just quickly do one more case, just because I think this is an important one that sort of feeds into the last, which is in relation to pressure which individuals might feel, and the reason as to why they might acquiesce in particular circumstances. So why you might engage in something like, say, sexual banter, or why you might put up with or tolerate certain behaviours could be because you feel that if you were to communicate your discomfort, it could get to a point where you might sort of lose favour with your manager. And there was a case called Munchkin's Restaurant, the Carmarthen, where basically in this case you had circumstances where the manager of the restaurant forced the women in there to wear short skirts and would also often ask them questions about their sex life. Now, in that circumstance, the women themselves were all European and had come over and had relatively unstable jobs working at the restaurant, and they were keen to keep those jobs. But at the same time, they were conscious that if they didn't play into what the manager had wanted, they could threaten their position. So as a result, they gave in to this behaviour and essentially played into it, answered it, did what he told them to do. But there was never a sense there that they wanted to do these things. These were just mere coping strategies that they had implemented to try and deal with this individual. So I think what's really important here to bear in mind is that whilst it might seem rather simple on the surface to really make that assessment between welcome and unwanted conduct, it's also really important to bear in mind the context. And I think what you're seeing in the case law as it's evolving and developing is an emphasis away from looking at the perpetrator and a shift towards looking at the impact of the victim.
Yeah, absolutely. And thanks for that explanation of unwanted conduct. The case examples really help to bring that to light and explain it. So the next part of the definition is that it has to be of a sexual nature. Alex, can I turn to you to ask you to explain how is sexual nature being defined here?
Sure. Yeah. The term of a sexual nature is used in section 26(2) of the Equality Act, as you've seen. But unhelpfully, we don't get any other guidance within the Act as to what exactly that means. I always think a very good starting point that I would refer people to is to look at the Equality and Human Rights Commission, the EHRC, as Aman's just mentioned. They have a guidance note, which is fairly recent, January 2020, I believe. And that just gives some really nice illustrations around what is and what might be constituting that sexual nature in terms of the conduct. So they actually give sort of lists of examples, and to name a few, it includes things like sort of sexual comments or jokes, displaying sexually graphic images, posters or photos. And I think we've all, as practitioners, WhatsApp seems to be the source of much evil in that regard at the moment. Suggestive looks, staring, leering, intrusive questions about people's sex lives, clearly explicit messages direct to individuals, and also the physical, so things like hugging, kissing, touching individuals. The second thing I would say, in some ways very similar, but also useful to look at, is we have a relatively recent ACAS guidance note for employers, which is March 2021. that's also worth reviewing. And look, I would say, Julie, whilst some things I think most people would look at and say, well, look, that's obviously sexual in nature. Others are open to interpretation, and people have their own subjective views about these things, clearly. And that's where I think we often, that's often where we would more likely get involved, where it's a bit more complex around it. So what, if I may, I'd like to do is just touch on a couple of cases that I think illustrate the point. The first one being in situ cleaning company and heads. Key sort of facts in this case really are, we had Miss Doreen Heads. She was the claimant. She was basically an area supervisor. This was a company dealing with leisure and commercial premises. And amongst a number of other complaints, the key one really was that she was standing in the office chatting to some staff members, and her manager walked in and said, "Hiya, big tits," to her. She found this remark very distressing, and felt embarrassed by it, especially because she was in front of other people. She brought a claim for sexual harassment. She succeeded in that claim at tribunal, so the first instance court. What's interesting about this case is that it was then appealed by both the manager, who she brought a claim against individually, as well as the employer. And the grounds of their appeal were quite interesting, I think. They argued that this remark, "Hiya, big tits," was not sexual in any way. And they said, and I've got a quote here, they said, "A similar remark could have been made to a man, for example, in relation to a balding head or a beard." So it wasn't sexual, it wasn't sex related. And the EAT, slightly unsurprisingly, gave this fairly short shrift. They said that it seems, quote, "it seems to us to be absurd. A remark by a man about a woman's breast cannot sensibly be equated with a remark by a woman about a bald head or a beard. One is sexual, the other is not." So I also think this is a useful case to highlight that it's fairly established in other cases as well that a single act of sexual harassment can constitute a detriment for the purposes of this section. And the other interesting thing that this manager and employer argued was that, well, going back to what Amanda's just talked about in terms of it being unwanted, he said, well, how was I to know that this would have been unwanted? I couldn't have known that before I said it and had a reaction, which was an interesting argument. Unsurprisingly, was not thought well of by the EAT either. And essentially they said, look, the harasser doesn't get an opportunity to sort of test the waters to see whether he says something might be unwanted. That's not how it works, basically, as you might imagine. So the EAT ultimately did confirm that was harassment. A second case, if I may mention, again, because I just think it's quite interesting to illustrate things, is Moonstar versus Five Ways Express Transport's 2004 case. Quick facts, Moonstar was an employee. She was a data entry clerk, and on 3 occasions, in essence, she's sitting in an open plan office. She has a group of male employees who, for whatever reason, think it's a good idea to start downloading pornographic images onto their computer screens. And they're sort of talking about this, downloading it, sort of making jokes around it. Importantly, she doesn't actually see the images. They don't show them to her. And she didn't make a complaint at the time. She makes a complaint much, much later. Originally, the tribunal found that there wasn't discrimination. There wasn't harassment because it didn't meet that test we've been talking about. However, on appeal, the EAT substituted her finding for sexual harassment. And they made a number of sort of interesting comments around that. You know, they say that the effect of causing an affront to a female employee working in that close environment would be regarded as a degrading or offensive environment to this individual. And there was evidence she found it to be the case. And the fact that she didn't complain immediately at the time was not in and of itself a defense to the behavior, nor did it make it not sexual harassment. I also think this is quite an interesting case because it shows that actually the conduct doesn't necessarily need to be directed at that individual person. You know, it can be sort of overseen by someone and still constitute sexual harassment.
Yeah, thanks, Alex. And I'm amazed in that Doreen Head's case that the employer just tried to argue that, you know, making comments about a man's beard somehow is the same as talking about the, you know, the way that they did about Doreen Head's. So yeah, it's
very much so.
So that is clearly very sexual, isn't it? So I think it's probably also just worth highlighting here that there is a difference between sexual harassment and sex discrimination. Sex harassment is because of someone's sex and isn't sexual harassment. Now, ACAS gives what I would regard as quite a neat example of this. They give an example of Tracy. She's the only woman in her team, and her supervisor, Michael, makes comments about women that Tracy finds insulting. For example, he says that women in that industry shouldn't be allowed. Now, that would be harassment because of her sex or related to her sex. It's not sexual. But say then Michael starts making sexual comments about Tracy's body, gets very close to her, starts touching her arm, and that makes her feel uncomfortable, then clearly you can see why that is then sexual harassment. And here Tracy, of course, would make the complaint for both sex harassment and sexual harassment. So what I'm going to suggest as well is I'm just going to put back that slide that we had before, because just to recap about what sexual harassment is and where we're at the moment. So make sure I've put it on there. Here we go. Yes. So just to have a recap of what that is. And the element that we're now about to look at is the purpose or effect. Does it, you know, when it does it have that purpose or effect of creating the intimidating, etc. environment? Alex, can you take us through that, please?
Yeah, of course. So yeah, as you say, section 26(1)(b) says, you know, the question is, does it have the purpose, or secondly, or the effect? So let's start with purpose. You need to be able to show that that person themselves actually intentionally tried to create that intimidating, hostile, degrading, humiliating environment for the victim. If you can show that, then actually technically you don't actually need to go through the rest of the elements of the test. However, I think you and I both know, Julia, that that's actually quite a challenging test to get over, because what invariably happens is that individual says, well, you know, how was I to know? That not only was I not to know, but actually I certainly didn't intend that to cause offence. That wasn't my intention at all. So the point really here is that's actually can be quite a tough test to get over evidentially, intending to cause that offence. More often than not, therefore, cases will hinge more so on the second element there, which is this: did it have the effect? Which is clearly a different test. So intention under this second element doesn't need to be shown, right? And that's important. It doesn't matter whether the person intended to cause this or not. The question is, did it have that effect in the end? When we're looking at that question of effect, it's not entirely simple in and of itself. And there are sort of three key factors that need to be taken into account. And these are actually stated within the Act itself. The first that I think is worth discussing is this perception of the complainant. So, you know, how did that person, let's call them the victim, how did they feel in the circumstances? Did they, subjectively speaking, feel offended, degraded, humiliated, etc.? Did it create that environment for them? So very subjective. The second element, which is really, really important to also not forget about here, is an objective element. So whether it was reasonable, was it reasonable for this act to have that subjective effect? And I think this second element is becoming increasingly important, certainly in my experience of such cases, because I have, you know, I've definitely seen HR teams and managers get a bit too overly focused sometimes on, well, it's all about what this person feels. If they feel offended, that's it. It's sexual harassment. And that's not actually true. That's a big part of the test, but there is this second element of objectivity. So, as an example, if someone had really quite objectively abnormal sort of eggshell sensitivity, or used in the case law, hypersensitivity, they might meet the subjective test because they actually do feel quite offended by this, but they won't necessarily meet the full test because there is this objective element. Was it reasonable to feel like that? So quick case, I thought, to illustrate this point, if I may, is the case of Richmond Pharmacology versus Darlingwall, 2009 case. It's a racial harassment case as opposed to sexual harassment, but this piece of legislation is equivocal, basically. So it's a good example to illustrate that point. Quick key facts are that this was a manager spoke to a colleague who was of Indian heritage and said to them when they were leaving the role, "Oh, we'll probably bump into each other in the future, unless that is you're married off in India." So that individual brought a race harassment complaint. What's important to mention on what was found within the tribunal case was that there was a context to that comment, right? This hadn't just come out of the blue. So the individual who had complained about this had, it was found, on more than one occasion referred to the possibility of her needing to get married and give up work. There had also been, and she discussed that with this boss, and that her parents had sort of been wanting her, pressurizing her to get married in that regard. And that's what the manager argued the comment had arisen from. It was appealed to the EAT by the employer, and ultimately it was still upheld as being meeting that test for racial harassment. But it was said by the EAT that this was a very, very borderline case because they were taking into account the context of that comment around it, which, by the way, is the third element of this question of effect, all the facts of the circumstances. But also, I think what's useful about this case is within it, they did express comments about the fact that if a person was acting in a hypersensitive way, then that wouldn't have met the test. So there's that objective illustration that we've just been heard, the point we've just been talking about. I think have regard to all the context of the conversation and what all the circumstances, objective and subjective elements once you get to that part of the test.
Yeah, thanks, Alex. Yes, certainly a number of points, aren't there, that need to be considered to determine that purpose or effect. And then the final limb of it is looking at the hostile environment, etc. What is meant by that? Alex, can you take us through that, please?
Sure. Clearly, that is going to be variant per case by case, but let me provide an extra case to illustrate it. So there's a case called Weeks versus Newham College of Further Education. It's a 2011 case. And it's a good case because the Employment Appeal Tribunal, again, provided guidance on whether conduct has, in fact, created that intimidating, hostile, degrading, humiliating, offensive environment. This was a case where the EAT, so the Superior Court, upheld a tribunal's decision that a female employee had not been subjected to harassment by her colleague. This was a case of sex harassment, per what you've just mentioned, so slightly different, but again, the test is the same effectively on this aspect of it. So this involved a complaint about some gender-specific comments, and some of the key comments made were that there was a complaint that people were talking about having girly chats, talking about power dress women, and more memorably, there was this cartoon that was circulated. It was sent around as like a round robin email because someone thought it'd be funny, and it was a picture of an elderly woman with her nipples being twisted by a pair of hands. Whilst the tribunal, and that was obviously part of the complaint that was made, whilst the tribunal confirmed that the cartoon aspect of it was clearly inappropriate and should be dealt with via the employer's processes, it did, however, confirm that the original tribunal judge was more than entitled to conclude that on the particular facts and context of that case, it had not created, that email, for example, had not created that intimidating, hostile, degrading, humiliating environment. So drawing this together, really, it's what I would emphasize is context is all important, right? It's not nothing in this is the be all and end all, but context is very important. The fact that the conduct is not directed at the victim is a relevant consideration. And in that case, I've just mentioned, it was a round robin email, right? It wasn't just sent to her. I think it might have been different had that been the case. But that's not determinative in itself. It's just relevant. The timing of a complaint, relevant, but not determinative as well. And the frequency of the conduct as well. Again, relevant, but it can be a one-off event. So it's one of these, it is very, very fact sensitive.
Yeah, absolutely. And yeah, as you said, context is all important. So we've now covered all the main definition of sexual harassment. But there is another limb to sexual harassment, which is really connected to victimisation. And this is under section 26(3)(c) of the Equality Act. And that states that if an employee or worker is treated less favourably because they have rejected or even submitted to that unwanted conduct, if they're treated less favourably as a result, then that basically is a form of sexual harassment, as I say, more akin to victimisation. So I suppose examples of such less favourable treatment could be, somebody then being ignored because, that they've rejected those advances, demoted, or even, I suppose, dismissal. So that's just bearing that in mind. But now let's come on to, I expect the fact that many employers will want to know, can they be held responsible for the acts of a harasser? Aman, would you mind explaining to us about vicarious liability?
Absolutely, yeah. So vicarious liabilities might sound like an odd, complex legal term, but effectively, in essence, what it means is that it's a doctrine which underpins the fact that one party could be held responsible for the acts of another. So in the context of sexual harassment and employment law, this means that the employer can be held responsible for the acts of the employee. So in answer to Julie's question, the answer is, in theory, yes, employers can indeed be held accountable for the acts of their employees if they occur during the course of employment. And one thing that we should also bear in mind, and is sort of something we're seeing as practitioners a lot in sort of everyday matters that we deal with, is claimants who are also bringing claims not just against the company, but also against the individual or accused harasser as well. And mainly the ability to do this is provided by the Equality Act. But there is also a sense that by doing this approach, this sort of two-pronged style approach in naming respondents, you're also trying to seek some sense of comprehensive accountability, essentially not just pull the company up on permitting this behaviour, but also going against the individual as well. And in this respect, both parties would be found to be joint and severally liable. So what does this mean? Well, this basically means that if one party cannot pay, so for instance, let's say the company goes under, this would mean that the harasser or the accused harasser would be required to pay the entire compensation amount. So even if that would mean that the individual harasser's ability to pay such amount would indeed be limited. So it's an important consideration to bear in mind as well. And as well as that, I think more so than anything, it does just provide increased leverage when it comes to negotiations on a without prejudice basis. You have on one hand the company who are concerned about any reputational damage which might entail, and then there are obviously the accused harasser as well, who's thinking about career prospects and how that will impact him moving forward. So the simple answer, I suppose, to Julie's question is yes, in theory, employers will be held responsible for the acts of their employees if they occur during the course of employment.
Yeah, and you're absolutely right about that in terms of, so many claimants will bring the claims now against both the individual harasser and the employer as well. I see that a lot. Alex, can you provide us some examples of this, like vicarious liability in practice?
Yeah, sure. So let's start with what we mean. Aman's mentioned there. A key question is it in the course of employment? And a key case on that, really, in terms of what the judge's comments around that are, is Jones versus Towel Boot Company Limited, where they sort of deliberated on what this meant. And ultimately, the judges stated that, and to quote from it, the tribunals are free and are indeed bound to interpret the ordinary and readily understandable words in the course of employment in the sense in which every layman would understand them. So they're very much saying, look, it does what it says on the tin. Is it in the course of employment or not? Just look at it in those basic terms. You don't need to complicate this. And I think clearly what that does mean is that if something takes place where obviously you're in the workplace, you, the employer, are going to be vicarious liable. There are some exemptions like criminal acts and things like that, but broadly speaking, you're going to be liable. As ever with these things, it's not entirely that simple. And I think a case of Chief Constable Lincolnshire versus Stubbs is a common one that's quoted in this field, dealing with, well, what happens if it takes place outside of the office at some sort of social event, which is, it's not uncommon for these types of instances to happen in that environment when people have had drinks, they're out, etc., with work colleagues. So it is one of those more grey areas. And in this case, what happened was the harasser only exhibited this behaviour exactly at those types of events. So it was often when they finish work and they go out for drinks afterwards, not necessarily work organised events, just go for drinks after work. And the question obviously became, well, hang on, should the employer be liable for those acts because they weren't in the workplace? Were they in the course of employment? Ultimately, the answer was yes, they were. Because there was a sufficient connection to the workplace. This was like an extension of the workplace going out. But what I would say is interesting, some of the comments around this within that case, is that the judges said that it would have been different, essentially, had these two individuals sort of by total chance happened to have met walking down the street on a non-work day, and the harassment had occurred in that chance meeting, because that wasn't, even though they were colleagues, it wouldn't be very closely connected to the employment. So if I may, one further little quick case to illustrate this point, which is recent, and I think it's quite interesting because it involves social media. It's the case of Forbes versus LHR Airport Limited, 2018 case. And this was where what was being considered was whether a racially offensive image, again, applicable to sexual harassment, which was posted on an employee's personal Facebook page, was or was not in the course of employment, because a colleague basically saw that image on her Facebook and then made a complaint within the workplace. And ultimately, it was found that it wasn't in the course of employment because this employee had put this on Facebook in her own time. She hadn't mentioned any colleagues or the employer in the post. She just put it out there and someone had seen it. So that wasn't sufficient connection. So some quite interesting aspects to that vicarious liability element.
Yeah, thanks, Alex. And I suppose certainly that Stubbs case does provide us with a timely reminder. Some of parties may be looming just to take steps to make sure that inappropriate conduct isn't going to be taking place.
Absolutely. I've had quite my fair share of Christmas party cases.
Yes, absolutely. Now, there is that limited defence, isn't there, for employers in the legislation if they're faced with a sexual harassment claim. Alex, can you briefly explain to us what that's about?
Yeah, so we have a defence which we commonly call the statutory defence, because it is contained in this legislation, so the Equality Act. It's at section 109 of the Equality Act. And cutting it short, what it effectively says is that the employer, sexual harassment may have occurred, but the employer may avail itself of liability if that has happened, if it can show that it took reasonable steps to prevent that from happening, from doing that thing or doing anything of that description by the individual. So yeah, there is that there, but it is quite difficult to meet that test.
Yeah. And Aman, I believe you're going to take us through with some examples of what that looks like in practice, and in particular, what steps employers need to take to be able to use that statutory defence.
Absolutely, yeah. So obviously, following on from what Alex mentioned there, what can indeed employers do to try and benefit from that statutory defence? And I suppose the simple answer is probably stuff that you're already doing. So things like having policies in place, procedures for victims to potentially report these concerns that have occurred, strategies on how to help potential victims as well, if they are dealing with these types of issues. However, the issue is in practice that it's difficult to try and rely on this defence, because it's not it's very hard for employers to meet the threshold, but at the same time, it doesn't mean that you can't attempt to do so. In this regard, I really want to talk about two contrasting cases, two where one was unsuccessful and the other was successful, and look at what the key differences are between the two matters. So the first case I want to focus on is Smith and Renrod, which we discussed earlier. That was the sexual banter case in the office. And in this case, the employer, Renrod, tried to rely on the fact that the manager in question had actually been sent on a training course about sexual harassment and how to prevent it the year previously. And also the company indeed had policies in place which were to prevent such behaviour from occurring. Now, when the employment tribunal were confronted with this evidence, they basically said that the company didn't take a proactive enough attempt to actually implement these. So merely having these policies is one thing. It's another thing entirely to actually act upon them and ensure that they're actually used in practice. And that really is the sharp distinction in these instances. And a case where we can see that the statutory defence was actually applied successfully is that of Caspers versus Ministry of Defence. Now, in this case, you had the manager, Mr. McDermott, who was making sexually inappropriate jokes to Miss Caspers. He was making remarks saying that she was making her way through the male members of the team, and other intimidating, crude remarks like that as well. And Miss Caspers brought a complaint. Once the Ministry of Defence were confronted with that complaint, they suspended Mr. McDermott and investigated the matter, and eventually led to his dismissal. The question then became, how culpable were the Ministry of Defence in these circumstances? And the tribunal, when they ultimately said that the company, which had a dignity at work policy in place, which was compliant with European Commission guidance, and they took all steps to implement that action. So effectively, in this respect, they were able to rely on the statutory defence. So what's key here for employers to really consider is that they're able to identify what steps they can take to ensure that they're able to make these actions not happen and not be complained of. It's really a case that they need to have taken all steps, and it's a matter then for the tribunal to consider whether there were any further steps they could have taken. So it's not really incumbent upon the employer to ensure that they can prevent the employee in question from making the inappropriate jokes. What's necessary is that they take all steps which are reasonably practicable on their end to make sure that these comments and this type of behaviour doesn't persist. So realistically speaking, in summary, what the employer needs to do is as much as they can possibly do to ensure that this type of behaviour doesn't occur. And when such behaviour does occur, they respond to it quickly and efficiently. And in that respect, you would be able to benefit from the statutory defence. But the employment appeal tribunals in CASPERS were very keen to point out that merely having a policy in place doesn't grant a party carte blanche. It doesn't mean that you're going to be able to rely on the statutory defence at will. You're going to need to ensure that you act upon it and implement it. And there was another very recent case of LA UK Limited v. Gerland, and this isn't a sexual harassment case. It's a case pertaining to race discrimination. But here, it was really emphasised by the tribunal that it's integral not to let these policies go stale. That's their word. And you really do need to make sure that you have implemented all reasonable steps in order to take hold of this defence. So in practice, relying on Section 109 can be challenging, but it's not impossible. And parties should be able to ensure that they have robust policies in place, training facilities, reporting mechanisms. And if you're able to have these in place and also use them, ensure that parties have refresher courses and such like, then you can significantly reduce the risk of vicarious liability.
Yeah, absolutely. And my experience is actually that employers at the moment are just not doing enough in terms of the regular sexual harassment or equal opportunities training in order to be able to use that defence and the new, in terms of being able to comply as well with that new act that's coming in. Many employers I tend to find at the moment will state in any, ET3, their defence, that yes, we do have an equal opportunities policy. Then when you actually start drilling down into it, yeah, they have the policy, but no one ever reads it. There's never been any training. So as you were saying, Aman, really important there that, when somebody does do the training, you keep a record of that and then you diarise that for, say, another year for when it's going to be done. And I suppose the other thing is that, the equal opportunities training or sexual harassment training doesn't have to take very long in terms of the person doing it. Before we move on, I know that we've had a couple of questions in our chat. Thank you very much for that. Someone's asked about the references to the cases, and basically, yes, we will be sending that out to everyone in an email after this webinar. And someone's also asked about the steps that employers can take to adhere to the new legislation from October 2024. And I think actually what Aman has just been describing there is a key point of that. And as we're about to actually just come on to now as well about how to manage any sexual harassment allegations. So hopefully we'll provide you some more top tips on that, because I'm going to actually turn to Alex now, if that's okay, because I'm sure, Alex, you've got many top tips for employers. But what would you say are your top tips for investigating when allegations arise?
Thanks, Julie. Top tips for investigating these. Well, look, I would say, first of all, lots of the top tips I would mention here are the same for probably most investigations. But I do think that in the case of sexual harassment cases, they're usually, they are clearly often much more sensitive. And I do think they need more careful examination quite often. So I think one of the things I would say is make sure you look at and follow your own policy around this. It never ceases to amaze me that people have policies, and then when they actually come to do the investigation, they don't actually look at them or follow them. So that's an obvious one, I would say. Second, I would say, is think very carefully about who is going to do that investigation. We have these particular sensitivities around this. So I think ideally someone with a HR background, someone that has training in this area or a specialism around it. And if necessary, go external. We assist clients with this frequently. I would say it's very important, obviously, for that individual to maintain a really, really open mindset. Don't assume guilt. I've seen that often. Don't prejudge. I think a key consideration early on is usually going to be, well, how do we actually manage this internally? And suspension is can sometimes be a real knee-jerk reaction by employers. It's certainly something that does need to be considered, but that's the key point, right? It's considered. Don't knee-jerk. Don't just assume you need to suspend someone. You know, I worked on a case recently where the alleged protagonist was, you know, not really having any contact with the alleged victim. They were actually working in completely different continents around the world on different time zones, and there was very minimal chance of them really working together, especially if someone just asked them not to. Where that individual was suspended. And actually, I think that wasn't right. It was unnecessary, because once you get suspended, it has an impact on that individual. And at that moment in time, you don't know if they've done the act or not. So I think have a careful think about that. And it's not necessarily the go-to option. You know, as I say, depends on the circumstances, but there are other options there. A key one, I would say, that often I can see people fall down on as well, is keeping the key people involved in this updated on what is going on. I think it's so easy for when you're investigating to get a bit bogged down in focusing yourself on the investigation, and you know what you're doing, but then you've got often two people, one that's had a pretty serious allegation against them, is sitting there sometimes at home not knowing what's going on, very worried about the situation and their reputation, and the other who possibly has suffered as a result of this act. So keeping both of those people updated and informed. I have to say, I usually find that employers are better at keeping the alleged victim informed than the alleged perpetrator. So that's a really key one, I would say. Don't forget about the alleged perpetrator. Inform both. Offer support, obviously, to those individuals. Maybe you've got an employee assistance program. It's a very stressful time for everyone involved, usually. Leading questions. I mean, this sort of slightly goes to keeping an open mind that I've mentioned, but I've seen it where people just are not careful about the questions that they're asking in that investigation. Don't lead people into your own conclusions. Ask open questions. I think another one I would say is, and it's really due to the nature of these, just my experience of these types of scenarios, I think they more often than not can involve a scenario where it is very much one person's word against another. You know, often it's two people together, one saying one thing, one saying the other. He said, she says. And that inevitably is going to be challenging for an employer to deal with when it gets to following the investigation to that disciplinary stage. So I think as an investigator, if you're in that scenario, you've got to really think about how difficult that decision is going to be later for the person dealing with the disciplinary, and to factor that in, and to really probably do a more thorough investigation and look at, is there any other corroborating evidence? Even if they weren't there then and then, do they corroborate anything around what's gone on, and obtain that, because that's going to help things later and make the process fairer. So those are some of them.
Yeah, no, absolutely, I agree. I think the other thing is I would just probably suggest that, you know, when investigating an allegation, you get that person coming to you with their complaint, really, you know, get their statement straight away, because otherwise memories can fade and things like that, and it's just better just to collect it then. And I know, Alex, that you've dealt with a situation recently where an employer handled an investigation really poorly by asking some leading questions to the victim.
Yeah, absolutely. I won't go into all the details, but, you know, in that case, as an example, the you know, and slightly shockingly, it was by a solicitor who conducted the investigation, who I think should have really known better, was asked by the alleged victim, who incidentally hadn't actually made a complaint herself. The victim asked the investigator, well, what she thought, whether she thought she should feel upset or how she should feel about this incident. And instead of doing what the investigator should have done, which was to say, well, look, this isn't about how I feel about the circumstances. I'm asking you questions about how you felt and what went on and the facts, etc. And basically not really answered to give her views. She did the complete opposite. She went on this sort of diatribe saying how she thought it was absolutely outrageous that that this had occurred, and that this person shouldn't have done what they did. And had she been in her shoes, she definitely wouldn't stand for it, and no one should, you know. And it put the employer, I think, in a very difficult position indeed later on. So don't do that.
Yeah, absolutely. No, don't do that. Very bad solicitor there. So, Aman, I'm just going to turn to you to look at one of the tricky issues, which you already touched on. Is with that, like that he says, she says scenario. Can you explain to us about that and perhaps some best practice?
Yeah, absolutely. So I think when it comes to that situation, I think, as Alex sort of mentioned there, it's really important to for the employer to ultimately look at the evidence and take a view. At the end of the day, they're going to be the ones that have to look at the information and make a decision as to whether there is anything here. And in that regard, you need to take a preference on one side of the story over the other. So you do need to have this balancing act of looking at it on that balance of probabilities. You really do want to ensure that you are considering all evidence available and then taking a view based upon that. And as Alex mentioned, you do want to look at contemporaneous evidence, things that might support particular versions of event, anything that corroborates either side's version of the story. So they're the main sort of key considerations that an employer needs to take into account when making that decision. But ultimately, the decision is one for the employer to make. I think you're on mute.
Yeah, absolutely. And yeah, I think it is. Yeah, thank you. Yeah, I think it's obviously one of those it is a difficulty, isn't it, for employers? I think it's very difficult for them to handle. And one of the things I would say is that sometimes employers can have a situation where you've got somebody that they really want to keep, but maybe that's the perpetrator, and then you've got the victim, but you've really got to put that completely to all one side. And what about when you've got like a reluctant witness? Aman, can you tell us briefly about that?
Yeah, so this might be a case where you have allegations come to light to you, and it may be a case that the individual who is the alleged victim doesn't want to participate or be engaged in the process at all. It could be a matter that they're fearful of getting into trouble themselves. They think that this might lead to some form of retaliation, their job can be at risk, or perhaps they don't want to get the person who maybe harass them into trouble. So I think what's really important here for employers to bear in mind is that they should indeed take into consideration what the employee wants, but there could indeed be an issue here where they need to intervene anyway, because obviously there's a need to get involved. And the EHRC do offer guidance in this respect as well. And they should say that employers should take steps to resolve the issues, even if the witness themselves are reluctant. And there are ways that you can deal with this situation in terms of alleviating any concerns that the victim may have. So, for example, you can offer support, whether that be sort of internal or external, and you can obviously ensure that confidentiality is maintained as much as possible. There is a caveat, though, in this respect, because if the matter is to progress to a disciplinary, the likelihood is, of course, that the facts and the circumstances will eventually get out to the individual who has been accused. But it's really important that the employer does not only consider what the employee in question is feeling, but also takes into consideration all those overriding interests that they have. So things like safety risks, and then make a judgment as to whether any formal action really is required in that circumstance, but really making sure they pay attention to their obligation to their workforce.
Yeah, I'd agree. Definitely confidentiality, should be maintained as far as possible. But we have actually one question that's come through directly to us. And Alex, I'm going to ask you to touch on this. And that is that what happens if you've got an incident that's being reported now, but it happened ages ago, so well in the past. Right. How should that be handled?
Sure. So I would say that I do think you need to be, where it's historic, you are going to have to, from the offset, make sure you're very strategic about the way in which you're going to approach this, because there, of course, are inherent increased difficulties looking into that scenario. So I think very much more so, sit down, think about what you're going to do, where you're going to go with it, who you need to talk to, the timings, who was about then in the workplace, and move on from there. So a real key strategy needs to be in place. Again, I think it's even more important to make sure that you have someone who frankly knows what they're doing in that regard and has some experience of it. But that is, can be really difficult and complicated. I do think, on a practical level, I think that probably you're looking to have, when I've dealt with this, I've often had more than one interview with the alleged complainant right at the start, just to really information gather, fact gather, timings, who was where, when, get all that down really, really clearly, and go back to that person if you're not sure about it before you start, going back into the history of it. So I think that obviously deal with it sensitively as you would anyway. Clear problems are, witnesses' memories are going to have faded over time. There's not a lot you can do about that other than go and speak to them and try and present them with the facts and get their input. I think what I would say, and I have seen, is that some employers are sort of really reluctant and sometimes just sort of have the approach of, well, we can't possibly contact someone who's no longer working for us. And I don't really subscribe to that. I think that you're doing that type of investigation, I think to a certain degree you owe it to that person to do your best to look into those aspects. And I don't see anything wrong with asking people who are no longer employed whether they would be willing to speak to you. Obviously, you can't force them to do that, but I think asking them to do it is perfectly fine and probably should be done if they're relevant. So
yeah,
there's no simple answer. It's complicated, but those are some of the aspects I would answer.
Yeah, no, that's great. Yeah, I think in my experience as well, historic complaints tend to be raised where maybe the alleged victim is facing a disciplinary, performance issues or dismissal. That's not to say that the complaint isn't genuine. I suppose you do need to ask the question of the alleged victim about why is it that you're raising those points now and not look at later, not raised it earlier. So just conscious of the time. Obviously, this topic is one of those ones where you could talk for ages and ages on, and it's, there's definitely lots to be passing on to employers about this. So I think, as I say, it's an interesting topic. It's really important that employers do get it right. One, because defending a sexual harassment claim can be time consuming. You've got the reputational damage issues to consider, but also the impact on your workforce, because that study that I mentioned at the beginning demonstrated that people that had raised sexual harassment with their employer, unfortunately, a large number said that they were just not happy with the way that it was handled. And for many, it did result in them, looking for another job. Now, that's all a bit grim, but that is why it is so important to get it right, particularly with that new duty coming on employers from October this year. So with that in mind, I would like just to let you know that we are going to be offering a free 30-minute consultation for those people that have joined today's webinar. And that would be a consultation with one of our employment solicitors to help to address any specific questions or concerns that you may have. I understand that we'll be sending out some details about that in the next 2 or 3 days. So look out for that in your inbox. And we're publishing as well a recording of this webinar. If you want to share it with colleagues, please do so. Excuse me a second. And future webinars, we've got a number of different things that are in the pipeline. Again, we'll be sending that out to you by email. Excuse me for this frog in my throat, excuse me. So I'd like to really just then say a massive thank you to both Alex and Aman for their efforts today, and also a thank you to all of you for your for those people that posted questions, for you saying hello, and just for you being here. I'm just going to double check that there's no other questions. So if you do have any, as I say, do get in touch with us. But for now, thank you very much. Thank you.
Thanks, Julie.